That's 5-0, Carl. We're on regular action, 13-00390 UT, in the matter of the application of Public Service Company of New Mexico for approval of abandoned San Juan Generating Station Units 2 and 3, issuance of certificates of public convenience and necessity for replacement power resources, issuances of accounting orders, and determination of related rate-making principles and treatment.
Madam Chair, Commissioners, I have a memorandum in order in your packet for today. The proposed order is based on the current status of this case, which I'm just going to quickly reiterate, which is that, as you're aware, this matter was at a hearing, an extended hearing before hearing examiner Ashley Shanauer on the proposed stipulation entered into by the parties. A certification was issued by hearing examiner Shanauer on April 8th. The certification, basically, to reiterate, would approve PNM's request to abandon San Juan units 2 and 3 effective December 31st, 2017, and allow for recovery of 50% of the undepreciated value of units 2 and 3. That abandonment would be subject to the Commission's further approval of PNM's plan to provide timely, adequate replacement capacity for the retired units. Certification also would have required PNM to file a plan for acquiring adequate replacement capacity within 15 days of the stipulating party's acceptance of the hearing examiner's modifications as adopted by the Commission, should the Commission adopt the certification. While the stipulation included PNM's request for a certificate of convenience and necessity for an additional 132 megawatts of San Juan Unit 4 as part of the replacement of the capacity lost in the retirement of units 2 and 3. Certification recommended that PNM's request should be denied based on PNM's failure to reach final agreements for restructuring of the San Juan project participation agreement and the post-2017 coal supply for San Juan Generating Station. The hearing examiner in his certification found that the parties' PNM's failure to reach final agreements created large and continued questions about the ownership of San Juan Generating Station and the availability of a fuel supply. Basically, the certification was concerned that approving the CCN on a conditional basis would require the Commission to act with essentially no updated knowledge of the interests, concerns, intentions of the San Juan owners regarding the restructuring of the ownership of San Juan Generating Station, and with only limited knowledge about the negotiations for the post-2017 fuel supply. That certification is still under review by the Commission. However, as everybody's aware, there have been additional developments since the issuance of that certification. PNM submitted a notice and proposal to the Commission, which contained evidence of various agreements that are underway, and the idea behind PNM's submission is that the Commission should consider it but not consider it. Is in essence what the argument has been. They're saying that that's consistent with their position that they would, if they did not have a binding agreement by May 1st, they would submit an alternative plan to the Commission. What I have in front of you is an order, a proposed order for your consideration that recognizes the significant development that PNM has asserted has taken place in reaching a coal supply in principle with Westmoreland Coal Company. it recognizes that this agreement is outside of the scope of the record, the evidentiary record that has been developed in this case, and proposes an opportunity for the commission to consider that in the proper fashion. The proposed order that I have for you basically would require PNM to file copies of the final executed agreements for the restructuring of the San Juan Participation Agreement and the post-2017 coal supply agreement by July 1st, 2015. PNM has asserted that it would not be able to do that until August 31st, 2015. In the event PNM were unable to file final executed copies of those agreements by that date, PNM would be required to file plans for alternative replacement resources sufficient to replace the capacity of San Juan Generation Station Units 2 and 3. Supporting testimony would be required to be filed at the same time. This is in recognition of the developments that have taken place and is an effort to have consideration of those developments take place in a proper proceeding subject to the requirements of due process. The scope of the hearing would also permit the parties to address, as I said, to address the alternative replacement resources. And that's in an effort to avoid this, or rather to avoid expending the parties' resources in a proceeding that might have only a limited scope. This would expand the scope further. As I said, basically, there are two arguments on this issue. The issue is that one is that the commission should reject these new proceedings and decide the matter purely on the record that has been developed. The order that's in front of you would, in recognition of the significance of this issue to the people of New Mexico, would provide an opportunity for the commission to make its decision basically with all the information before it. This is a decision that, to me, is not a legal decision. This is a policy decision for the commission. But the order that I've drafted provides you with that opportunity. The order that was initially circulated to you contained a July 1st, a deadline, a true deadline of July 1st. I did revise the order to provide an opportunity for PNM to make a showing that it might require additional time to reach these executed agreements. I've set a deadline, a deadline for for PNM, rather, to make such showing, and upon cause that it needs that additional time. I would have them file a request for additional time by June 3rd, and the parties would have until June 10th, which gives them 7 days, including the weekends for for PNM and the other parties, to make that showing and to respond to it. And that would allow the commission to consider that request for additional time by June 17th, and that would essentially give PNM, if whichever way it goes, enough advance notice to know whether the commission has granted that request or not. Stand for questions.
Questions from the commission?
Madam Chair, a question to council.
Yes.
Are you going by calendar days, or does calendar days include the weekends?
Yes, it would be 7 days, including the weekends.
Weekends. And that's your recommended 5 days to give PNM time if they choose to have to request extended time?
Yes, that's correct.
Or additional time? Is 5 days sufficient? If that includes weekends?
Madam Chair, Commissioner, I'm basing that on Since July 1st is a substantially shortened amount of time from the August 31st date that PNM has set forth in its notice and proposal, it gives them the opportunity to make that showing, but they should know the facts at this time, what would be the base, that would provide the basis for their request. I think 7 days gives them an adequate opportunity and allows the commission to act on it, to put it on an agenda and to act on that request, to give them the opportunity to respond by July 1st. If we put it on, gave them any more time than that, then we would essentially have the request before us right before the July 1st deadline. And if the commission were to deny that request, then PNM would basically not have really any opportunity, to react to that. In essence, we would be denying it right before the pleading was due.
Madam Chair, Council, is this a clear indication now that either PNM follow the good faith effort and supply the needed information, that there will be no more time after the timeline set in this order?
Madam Chair, Commissioner, I do have that. If the commission were to consider granting a request by PNM for additional time to submit those executed documents, that the drop dead deadline for that would be August 1st, 2015, that the commission would not consider extending that beyond August 1st.
August.
In essence, this would provide PNM the opportunity to get the signatures it needs, to put those documents in final shape and give them to the commission, and for the commission to set this matter for a hearing and in enough time to get this done.
Thank you. Michael, I have a question as far as the issue related to, hasn't it always been the case that in these instances that contracts are signed and then they are subject to commission approval?
Madam Chair, Commissioner,
Is that how the norm?
that is typically the way things are done. I know PNM has made assertions that basically they need it the other way around, but typically the parties are able to reach an agreement which then comes to the commission for approval. And those agreements are contingent on the parties getting the necessary regulatory approval.
Thank you.
I was hoping to wait till everybody was done, but
Commissioner Wyden?
Okay, let's talk about the new paragraph 13 is put in there on page 4 and 5. He says any such, on page 4, any such request shall be filed no later than June 3rd, 2015, and must be supported by the facts. An extension must be filed by June 10th. I don't understand why you allow them 20 days from June 10th to July 1st, I guess, would be the deadline for everything to be filed. Looks like they may get something done there that we should change that June 10th deadline to June 20th to me. If they don't have anything by then, we can file a request. Because there's 10 days to file a request.
Madam Chair, Commissioner, the dates I picked for an extension request, as I said, would allow the commission to make a decision on any request by PNM with sufficient time that if the request were denied, PNM wouldn't be left having only 5 days to get their documents in. This allows them 7 days from today to file a request supported by specific and verifiable facts, and for the opponents to that request, an additional 7 days from that period.
Well, they're gonna file that extension regardless, because you're just giving them until June 3rd. So what you're just saying is just, they're gonna file an extension until August 1st, if they don't get it done in a week. Right?
I'm not sure if that's a question,
Well,
Commissioner.
okay,
but-
just take it as a comment then.
Yeah,
No question. So, I don't, they're gonna file an extension, we're gonna have to go over this again, well, I'll just put August 1st for me, but that's all right, if you wanna do it that way, that's okay.
Madam Chair, Commissioner, I just wanted to, I put a schedule on there that would allow the commission to decide the issue with sufficient time that PNM would still have an opportunity to react to the commission's decision in the event they didn't get the relief that they sought.
Yeah, so we'll have it back in front of us whether they give an extension or not, so.
Right.
Period, that's what's gonna happen, so I'll just do it today and put it August 1st, but we'll let the rest of the commission comment on that. And then it says under the last sentence in paragraph 13, under no circumstances will any extension extend beyond August 1st. And, you know, there's a lot of moving parts here in this case, and I think when you put under no circumstance, that's really tying the commission's hands. I'd say unless there's extraordinary circumstances for further extension, there will be none, rather than just absolutely saying, under no circumstances. Something could come up, I don't know what it is, I mean, you never know, there's a lot of moving parts here, so that's just my comment on it.
Madam Chair, Commissioner, I just want to let you know, I put that in there because as I noted in my sort of preface to this, the certification, the issues that the hearings never had at the certification were significantly based on the failure of PNM to reach executed agreement, final agreements on these issues. And from the very beginning of this case, that has been an issue, and there have been repeated assertions by PNM that those agreements would be forthcoming within basically a moving target date that has continued through this whole proceeding. We've got the same situation in front of us, and as I said, it's a decision for this commission whether the commission wants to adopt this order and give PNM this additional opportunity to make that showing. But I put in that language, I chose that language because at some point there should be a need for a final resolution. The other parties who opposed the stipulation have already suggested that we've reached that point by the end of the hearing on the stipulation. As I said, this is a decision, a policy decision for the commission, and I'm offering you this form of order with that kind of a deadline in there in an effort to basically draw a line on that.
Well, I'm just saying, it could be like Houston, Texas, where you're flooded out, can't do any business for a month. So, when you put absolutes on something, it's not a good thing, I think, but that's just my comment. That's all I have, thanks.
Okay, thank you, Commissioner.
Thank you, Chair. So you're giving the commission an opportunity to allow PNM more time?
Madam Chair, Commissioner, the reason that I have tendered it to you in this fashion is because PNM has essentially filed documents that, in the form of that notice and proposal with these new agreements, that basically dangles in front of the commission the specter of final executed agreements being done by August 31st. And while they say that should not affect the commission acting only on the record that was developed, the very nature or very name of the filing, a proposal to the commission, suggests that it's, despite what PNM's saying, that they are essentially requesting that this commission consider that filing in determining on whether or not to approve the certification.
So really what we're doing is delaying and pushing things further and further and giving them more time. Get the records closed, it's been developed, it goes back to Ashley's decision. They need more time. I think we've given them an extension, how many times now, 2 or 3 times since? Because you already have given them a drop dead date for the executed agreements. Now you want an extension, you want us to approve an extension, and then earlier on you mentioned we could accept or not accept. Could you go back to that point to help me understand what you meant? Like who recommended that we could accept or not accept earlier on in the presentation?
Madam Chairman, Commissioner, I think what you're referring to is, what I'm saying is that, obviously, that this is a policy choice for this commission. The proceeding went through a hearing on the proposed stipulation. The certification was issued by the hearing examiner. At that point, the commission would normally make its decision based on the certification that the hearing examiner has tendered. However, as you're aware, that the significant issue of Unit 4 was not determined in that certification based on final agreements, because those final agreements were not reached. PNM has now, after the close of the evidentiary record, essentially said, now the agreements are imminent. And I will say that, after several times throughout this proceeding, saying that they're expecting that they would reach final agreements by various dates that continually were pushed back. This would give them, if they are sincere, and that these agreements, now that they have actually reached an agreement in principle with Westmoreland Coal Company to actually acquire ownership of the coal mine, this would provide them a last opportunity to reach those executed agreements and tender them to the commission. The record would be reopened to consider those agreements consistent with due process, to provide the parties an opportunity to review those agreements, because no one's had an opportunity to review those agreements in an evidentiary hearing, and submit evidence and cross-examine PNM on
Right,
those
but then this
agreements.
would be new evidence, right? And so maybe someone's looking for a different outcome.
Madam Chair,
Or the same.
Commissioner, I can't disagree with you on that. That people are seeking different outcomes in this case. PNM has one position. The opponents to PNM's CCN for Unit 4 have a different position.
And I have a different position too. I think it's time to vote this thing down once and for all. I think, I listen to my constituents, and a decision that I make today would impact myself 10 years, 20 years, for those of us who are still around in 30 years. So this is too important to be granting extensions, in my opinion. And so I think the record's been developed and it's been closed, and the more opportunities you mentioned, providing more opportunities to get signatures, to me isn't in the best interest of the public. I think there's been promises made already in the past, and today's the day. I mean, we don't need to be extending this and giving more opportunity or ample time to get anything done. They have a lot of, heavy attorneys, and we have limited resources, limited attorneys here, and the community has limited resources to be fighting this. And so I guess that outcome is not going to get decided with my vote. So again, I don't think we should be, it's not in the public interest to be granting extensions. So I think you know where my vote's going to go. Thank you.
Thank you. Any other questions from the commission? Commissioner Jones?
Mike, on the, I just want to make a couple of things clear in my mind. In a minute, I want to discuss a little bit about what Commissioner Lyons had to say about tying the commission's hands. Well, let's just start with that one. That's on page 5. top paragraph, under no circumstances will any extension be on April the 1st. I think, excuse me, I don't know why I can't talk this morning, I'm generally pretty good at it. I think, to me, the issue beyond August 1st, if I said April, anything beyond August 1st really puts the commission in a position. Let's say the commission was to reject the STIP, as Mr. Espinosa's may be interested in. What would happen then? I mean, it would fall back and be litigated, correct?
Correct.
So what we did in this entire case is we considered a stipulated agreement the parties brought forth, which everybody understands just is slowly eroded and unraveled, so that I don't even know who all's hanging their hat on the STIP at this point in time. But as I recall in the hearings, a very significant part of the hearing was whether or not, I think Ashley got it right, decommissioning the two plants. That's significant because that's an order from an agreement between the state of New Mexico and the EPA. So, I think that was a significant piece of the cake. But then another piece that was very significant was the availability of coal, since the mine is scheduled to shut down, I think in 17, somewhere in there. So just the availability of the coal and the ability to mine the coal, to me, was a very significant part of this stipulation and the hearings that we had. So because of that, I support allowing that to come into the record, provided that those contracts are signed. That makes sense to me. What concerns me is if we don't do this proposed order, if we don't do that, I think the commission is forced into two things. One, we either reject the STIP, accept the hearing examiner's recommended decision, which then trumps the PNM or one of the other parties in order to approve or disapprove. So really tying our hands is not going forward with this proposed order, in my view. In other words, if we reject the STIP, I think we have, there becomes fully litigated, possibly appealable. If we accept the RD, then it becomes one of three parties, I think, that's left decision. If they drop out, we may not have a stipulated agreement anymore. So just because of that, I think this makes sense. But it also, I think we need to, I hope PNM hears that, we really need, we need concrete evidence, signed contracts and coal agreements in order to make the right decision here for the process. And I just think we are really out of time. And so I support the short fuse on this, and I hope parties will work on it quickly. But I'm gonna ask one other thing of this. Would there be any reason or any merit into adding into this order either the hearing examiner or the chief hearing officer to ask parties if there would be any value in a quick mediation on this? Would that be of any value, or would that further expedite it, or what's your opinion on that? I suppose that any one of them could offer it up regardless. What's that?
Mediation's gonna take a lot of time.
So you think take more? I'm fine.
I think, and Madam Chair, Commissioner, we'd still have the same process at the end of that.
So if they wanted to come if parties wanted to come forward in the meantime, they could come up with some agreement anyway. Another agreement, how's that?
Madam Chair, Commissioner, there's so many moving parts in this.
Exactly.
It's kind of difficult for me to speculate as to what type of mediation would really shorten this process.
And I didn't want to further confuse this further, so. But again, my concern here, I know this has been a long process, and I think that, you know, it's one of those cases where I think the hearing officer actually did it, you know, he's really worked hard trying to get this done. I think it's unfortunate that we're this far down the road, and I mean, I think there's a real sense of urgency here to expedite this. Is there any, I want to ask the last question. Beyond August 1, this August 1 date is a critical date, is it not? Could you just reiterate a little bit more why that's so critical?
Well, Madam Chair, Commissioner, it allows this matter to get back to the hearing examiner in sufficient time that we're not going to carry this case over. As you're aware, that the initial stipulation was subject to an extended process of hearing. And we need to get this case done before we move into next year and we start running into all the deadlines for what replacement power would be feasible to be in place by the time PNM is required to retire San Juan 2 and 3, should that be approved by the commission under the revised SIP with the EPA, or rather, required by the EPA.
Okay. I'm done, Madam Chair, thank you.
Thank you.
Mike.
I'm going to say one thing. I am going to support this order. And I feel like it's important that all the information is vetted, any information that could be obtained. And I think it's in the best interest of the people of New Mexico to bring forth anything that could be viable for this process to have a good outcome for them. So that's why I would prefer not to limit the information as opposed to bring it into the process. So that's all I have. Anyone else?
Madam Chair, I think it's time to send a very stern message to PNM. I think this commission and staff who have worked so hard throughout this whole hearing and the various processes that's been dedicated to responding to and accepting PNM's piecemeal documents and still not producing the most important information that's been needed. I strongly feel PNM has not really made a good faith effort up to this point. We've each been flooded with emails. PNM has paid for a campaign that that has raised a lot of hopes for community people in the Northwest region, those who have jobs and those who have prospered from jobs for many years and have kept families intact and have made a good living for well over 48 years, as long as this facility, this plant has been there, and as long as the coal mine has been there. And so we've recently been flooded with so many emails. And if anybody is going to pull the plug to destroy or devastate Northwest economy, and negatively impact the livelihood of those
Joining the
people
meeting.
who have high
The
hopes
officer entered the
that,
courtroom.
that something good is gonna come out of this case, then the people that are going to pull that plug is gonna be PNM. It's not gonna be the commission. It's not gonna be the staff. It will be PNM. So you decide if you're gonna pull the plug and devastate everything, or you come with what is needed in order for this commission to make a decision. And so, Madam Chair, with that, I am ready to make a motion.
Oh, please.
Madam
My
Chair.
motion is to approve the order as is.
I'll second.
Did you want to say something?
Oh, I was just going to say, as we discuss sending messages, I think this sends a bad message to the consumers, those that live on a fixed income, who use a little change to give back. And so I haven't given my spiel on this to this audience, but I was in Penasco at a senior citizens community center at a little sale they were having, bake sale. I purchased an item and the little lady gave me $2 back in change. That's how I make my decisions. So go ahead and take a vote so I can vote against.
Okay, we have a motion and a second. All in favor to accept order setting further proceedings? All in favor, say aye.
Aye.
Aye. All opposed? No. All right, we have a 4-1. Carl? And do we need to identify anyone on the phone? I heard someone come in.
Hi, this is Nancy Oliver representing Shinter, New Mexico.
Okay, do we have anyone else on the phone? All right,